Thank you, Mr. Chair. Members of the committee, for the record, Brad Hudson, representing Missouri's 33rd Senatorial District, here to present to you Senate Bill 160. Senate Bill 160 is a short, narrowly written bill that solves a very specific problem. This act prohibits public institutions of higher learning, such as state colleges, community colleges, and technical schools, from taking adverse action against a student association because of the association's belief or the actions of its leaders. Specifically, these institutions shall not deny a belief-based student association, such as a political, ideological, or religious association, any benefits that are available to other student groups, including access to campus facilities and communication channels. A belief-based student association shall be responsible for defining its own mission, beliefs, and conduct standards, and may seek relief in a judicial or administrative proceeding against an institution that violates the provisions of the Act. The importance of protecting belief-based groups on college campuses has resulted in the passage of protective laws in 19 states, as well as a passage of a bill on this issue in the U.S. House of Representatives last fall. Many people are here to testify in favor of this legislation. I have received letters of support from Campus Crusade for Christ, InterVarsity Christian Fellowship, Christian Legal Society, and FIRE, to name a few. I'll give you a little background here. I'll be brief. In 2023, the Missouri House passed a very similar bill, HB 136, by a vote of 108 to 42. That bill was then voted do pass by the Senate General Laws Committee and by the Senate Fiscal Oversight Committee, and was placed on the Senate calendar for floor action, but too late in the session to get across the finish line. Last year, HB 1518, an identical bill to the bill you have before you today, passed the House by an overwhelming margin, 100 to 40, but was not assigned to a committee in the Senate until very late in the session. So far, 19 states have passed legislation like Senate Bill 160, designed to protect students and taxpayers alike, and I look forward to Missouri becoming the 20th state to adopt this common sense measure. SB 160 codifies existing practice at our colleges and universities so as to protect pluralism and avoid the potential for needless litigation that the state would almost certainly lose to the detriment of Missouri taxpayers, and I am happy to take questions.
Thank you, Senator. Any questions? See none. Anyone? Can I get a show of hands who's here to testify in support? Okay, testify against? Okay, all right. We'll go ahead and start with those in favor of the bill. Please come forward. Remember to fill out a witness form for anything that you are testifying for. So please come forward.
Good morning, Chairman and Committee. My name is Timothy Faber, and I thank you for the opportunity to be here this morning. I am here to speak in favor of Senate Bill 160. More clearly, I'm here to speak in favor of religious liberty. The First Amendment to our United States Constitution states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. While that amendment does say Congress and not the state legislature, I would hope that this legislature would conduct themselves in keeping with the principles set forth in this great Constitution that has guided our nation and protected our rights for nearly 2.5 centuries. With that in mind, the government has no right to prohibit the free exercise of religion. Thus, if a religious body determines that certain tenets of faith are to be upheld, the government has no right to override that, except in very rare and clearly defined cases. Students are not exempt from this free exercise of religion. If a student organization determines to follow the tenets of a particular faith, they have the right, as citizens within these United States, to practice that religion and to determine who can be leaders of that organization according to those religious tenets. Additionally, the First Amendment guarantees the right of freedom of speech. If an organization has taken a public position on some topic, That position cannot be denied or restricted or compromised by demanding that certain persons holding different views be allowed to be a part of that organization, and certainly not as leaders. To force any organization to allow leadership which disagrees with their own tenets and public positions is to force a message on that organization that violates its own freedom of speech collectively and of its members individually. The First Amendment also guarantees the right of the people to peaceably assemble. But if any organization is forced to allow members who are in disagreement with it, and to even allow them to serve as leaders, how can that be peaceful? The organization would have internal conflict, and the rights of those who originally formed the organization would be trampled upon. Certainly, as an organization carries out its purpose over time, it may adjust its own parameters for membership and leadership, and they have the right to do so. But for the government or any government-funded entity, or really for anybody outside of that organization, to force such changes is a violation of the people's right to peacefully assemble. Thus, this bill, Senate Bill 160, is merely clarifying and codifying what the First Amendment of the U.S. Constitution already guarantees, because we are apparently some who need to be reminded of it. Thank you.
Thank you. Any questions? Seeing none, thank you for your testimony. Anyone else to testify in support, please come forward.
Good morning. My name's Curtis Cole, and I serve with Chi Alpha Campus Ministries USA. I'm here to stand in support of Senate Bill 160, primarily from a religious liberty context. First off, Chi Alpha is the campus ministry arm of the Assemblies of God nationwide. Here in Missouri, there are 445 Assembly of God churches with about a Sunday morning of attendance of 122,000 on any given Sunday. Chi Alpha on the local campus has chapters in Missouri on 7 different universities and 275 different campuses across the country. Everyone is welcome to come and worship at a Chi Alpha gathering. Students study God's Word, they worship Jesus, and they're encouraged to serve their campus and the world beyond. First, a little bit of national context. For many years, Chi Alpha chapters have been repeatedly faced with being kicked off of campus on universities around America, but in particular, even here in our home state of Missouri. Sister organizations have been kicked off of the University of Iowa and Wayne State University, resulting in years of expensive and difficult litigation. The question is why? Well, simply because those religious groups ask their student leaders to embrace their group's faith. I'd like to share 2 specific examples before getting, 2 general examples before getting specific into Missouri. The first one is at the University of Virginia. Our local chapter was ridiculed at student government meetings and in the student newspaper for simply holding biblically based views. Later, our chapter of over 425 students was threatened to lose its club status. And then out west at Wenatchee Valley Community College, our local group was kicked off campus and denied access to the college campus going forward because of our association with the National Assemblies of God Church. So why is Senate Bill 160 so crucial for Missouri? I see 3 simple reasons. Number 1, students in Missouri should be able to follow their sincerely held religious beliefs and organize their student groups and activities around those sincerely held beliefs. Number 2, I'd like to suggest that college administrators are facing pressure by student governments and activists in our communities demanding that religious groups be expelled for their religious convictions. Those administrators need a clear, firm rule like Senate Bill 160 that gives them the foundation to push back against the voices of unconstitutional discrimination against religion. And then finally, this legislation is valuable because I see it as proactive instead of reactive. Instead of waiting for issues like this to surface again at a campus in Missouri, this legislation clearly states that the definition of what it means to be free and religious in Missouri. I believe a favorable vote for Senate Bill 160 demonstrates respect for unique belief systems. It is an affirmation of our U.S. Constitution, and it supports religious tolerance in our great state. Thank you very much.
Thank you for your testimony. Any questions? Seeing none, thank you. Anyone else to testify in support, please come forward.
Oh, I better give my witness form here before I start speaking. Thank you, Mr. Chairman, members of the committee. My name is Lance Kinzer. I'm here on behalf of First Amendment Partnership, where we have the privilege of working with some of the nation's largest religious organizations on matters of common concern. I want to note the University of Iowa situation was mentioned somewhat in passing, and that case involved two lawsuits. One, a small evangelical campus ministry, Business Leaders in Christ, and InterVarsity, a larger campus ministry, both that were removed from campus because of their standards around leadership. And what does a leadership standard mean? Just put most basically, this means that religious organizations on campus would like those who speak a religious message on behalf of the organization, those who lead their Bible studies, those who lead their meetings, to share the religious beliefs of the organization. This is commonplace, it's common sense. In fact, the law in general allows religious organizations to use religious standards to determine who their leaders are in a host of contexts. This standard is so clear that when it was violated in Iowa, two cases went up to the Eighth Circuit Court of Appeals, the circuit in which Missouri sits, and they found that not only was there a violation of the rights of these students, but that it was such a clear-cut right that the individual administrators at the University of Iowa could be held personally liable. Now, ultimately, the state of Iowa subrogated to defend the almost $2 million judgment that was entered on behalf of the student groups that were discriminated against. Now, that whole story, it's a cautionary tale. It might lead us to think, well, why do we need this bill if the Constitution is so clear? And there's a couple reasons for that. One reason is that even when students win in these litigations, like they did at Iowa, like they did at Wayne State, like recently in a similar circumstance at the high school level, Fellowship of Christian Athletes won before the Ninth Circuit, recently out in California. Even when they win, this lengthy litigation to ultimately get a piece of paper from a court saying they shouldn't have done that to you, when you're a student club leader who perhaps has been preparing to be in leadership for 3 years, it's your year, you're swinging into senior year, you're excited about club day, and all of a sudden an administrator tells you, nope, you guys can't go to club day, you can't meet. And by the time you as a kid figure out, who do I talk to, what do I do, how do I get this to court, and even if it's just 2 or 3 months later that a district court judge says, yeah, they shouldn't have done that, your year is ruined in terms of something that you put a lot of time, effort, and energy into, so it's not good. The other thing is there is a little gap in the law, a very small one at this point, but let me just say this, and I've been going for a while now already, so I'm going to try to move quickly, but really, going back 50 years, the law was absolutely crystal clear. It was crystal clear that you can't discriminate against a campus student group based upon their viewpoint. That's Healy v. James from 1972. You know, the interesting thing about Healy was that was a case where you had a group that was protesting the Vietnam War. It was the Students for a Democratic Society. Their national organization actually called for the violent overthrow of the government of the United States. And the University of Central Connecticut said, we can't have this radical left-wing group on our campus. We're kicking them off. And the U.S. Supreme Court said, even though their national group has said some things that are problematic, we have to look at this specific group. What have they said? What have they done? Obviously, if they engage in incitement to riot, if they engage in illegal activity, you can deal with them. But just because they hold beliefs about the Vietnam War that the conservative campus administration at the University of Connecticut disagreed with, you can't kick them off campus. A lot of times the question is asked, does this bill somehow give aid and comfort to radical right-wing or radical left-wing campus groups? And the answer is, those groups are not going to litigate under this statute. These groups are just going to go back to the long, unbroken line of precedent, started with Healy v. James. You cannot discriminate against a campus group based upon viewpoint. If you're going to have campus groups, all viewpoints, as long as they act peaceably, get to be on campus. That's just reality. The next case is an interesting one because it was right here in Missouri. Widmar v. Vincent, 1981, an 8-1 opinion where the UMKC said a small evangelical campus group couldn't meet on campus because like the taxpayers are paying for this building. They're like paying for the air in the room, I suppose, however you want to view it. And it's an Establishment Clause violation. And 8-1, the U.S. Supreme Court said no, that those groups, regardless of their viewpoint, regardless of whether religious viewpoint or secular viewpoint, they can use campus facilities in the same way as anyone else can. Then in the 90s, so we have 70s, 80s, and now in the 90s, one of the questions that often comes up is, okay, we're fine. They can go to club day, they can use facilities, but what's really galling is that they have access to student activity fee funds. Well, first of all, a lot of times people say those are taxpayer dollars. No, student activity fee funds are student dollars that every student is going to end up supporting some clubs they agree with, some clubs they don't disagree with. And what makes that fair is that all viewpoints get to be represented. What would be unfair is to say we're going to collect student activity fee funds, but the university administrators or some small subgroup of students is going to decide which viewpoint, who can apply to receive those funds. The U.S. Supreme Court agreed with that with absolute clarity in Rosenberger v. University of Virginia in 1995. And I'll close with this, the one little hole is that in 2010, there was a 5-4 opinion by Justice Ginsburg that said, if you have if you have an all-comers policy, if you have a policy that says no student group can have any standard for who its leaders are, then that doesn't violate the Constitution. Now, that's an absurd policy. Almost no university actually wants to have an all-comers policy. No university wants to say the college Republicans have to let a Democrat be president. No group wants to say the campus equality group has to let somebody who opposes same-sex marriage be their president. It just doesn't work. And so universities almost never actually adopt an all-comers policy. But what happens is that administrators or students who have oversight over these campus groups who don't understand the law see CLS v. Martinez, they say, oh, we can restrict leadership standards. And they do. They do it in a ham-fisted way that ultimately results in litigation, and you get the University of Iowa with the taxpayers of the state on the hook for a $2 million judgment. So the point of this bill is simply clarity. 19 states have passed it. It hasn't resulted in any of the unintended consequences that folks are sometimes concerned about. And one of the key things, and what I'll leave it with, is that this bill is content neutral. It protects belief-based groups on both sides. And the political winds change. Which groups are ascendant, leadership at campuses change, and this protects the groups on the left just as much as it does the groups on the right. It has to do so in order to be constitutionally appropriate, but that's, from my perspective, this is a common sense measure. It's good for students. It's promotive of pluralism. The answer to speech you don't like is more speech, not restricting the speech of other people. And I think Missouri would do well to join numerous other states who have already adopted this policy. So I appreciate the committee's time. Thank you.
Thank you for your testimony. Any questions? See none. Thank you for your testimony. Anyone else to testify in support, please come forward. You can leave the witness forms on the desk and they'll get them, so just to make it easier.
Thank you, Chair Bratton, members of the committee. Good morning. My name is Logan Spina. I'm legal counsel with Alliance Defending Freedom. The form I just turned in says Lansdowne, Virginia, but I was born and raised in Peculiar, Missouri, so always happy to be here supporting freedom in our great state. ADF's Center for Academic Freedom defends the rights of students, teachers, and professors at America's public universities And we often, for that reason, represent student groups, which face unconstitutional burdens on their associational activity, and SB 160 would greatly ameliorate that problem within the state of Missouri. I agree wholeheartedly with everything that Mr. Kinzer just said, and so I'm going to try to be very brief in light of his excellent explanation for why the committee should unanimously support this bill. 2 brief points. One is that this bill is good for students. So it ensures that students enjoy what the Constitution already guarantees to them. So that is, the right protected by the First Amendment is the right of individuals to associate to further their personal beliefs. That's what Healy said, the case Mr. Kinzer talked about. And that freedom presumes a group's ability to control its composition. That's what association is. To preserve the group's ability to advocate public or private viewpoints. That's the Supreme Court statement in Boy Scouts of America versus Dale. This is something that students are already supposed to enjoy, and as Mr. Kinzer sketched, there's a lot of good Supreme Court precedent on the issue, but CLS versus Martinez in 2010 has served as a little bit of a fly in the ointment. And legally, Mr. Kinzer is correct that it is a very narrow opinion. It actually only protects universities when they adopt a true all-comers policy, which is something that students and universities alike generally don't want. However, because of that case, it can lead lower courts and district courts to fail to adequately protect students' freedom. And that's a really good reason why it's important to get a law like this on the books to sort of cut that problem, nip that problem in the bud, so that students don't lose the opportunity to actually work with their student groups, as Mr. Kinzer also explained. ADF right now is currently representing Young Americans for Freedom chapter at the University of Buffalo in New York. The adverse action there was different from what this bill would stop, but what happened there was the student association just banned all student groups from having affiliations with national groups. And they were targeting that club's association with the broader YAF, Young Americans for Freedom organization. Now that's something that Healy versus James would directly prohibit, because that's what happened there. They tried to ban them because of their association with SDS. But even though that's true, the district court dismissed their case just in December, citing CLS. So it's the sort of logic of CLS that gets abused, even though as the Eighth Circuit's precedent that's binding here says it isn't as broad as people think. Quick point number 2, and for this reason, this is a good bill for Missouri's institutions. Because CLS is really narrower than it is, it leads institutions to do things like they did in Iowa that get them into trouble, right? CLS only protects universities if there is a true all-comers policy, but nobody wants that. We want to be able to have fraternities and sororities. We want to be able to have religious groups. We want to be able to have groups for students who are coming from other countries to be able to associate with one another. There's all kinds of reasons why we don't want all-comers policies, and for that reason, most institutions don't have them. But when they try then to sort of have their cake and eat it too by letting some groups limit their leadership, but not all groups, that generates liability, and this bill would stop that from happening. So we urge the committee to approve the bill. Thank you.
Thank you very much for your testimony. Good to see you. Anyone have any questions? See none. Appreciate it. Anyone else testify in support? Please come forward.
Thank you, Mr. Chair, members of the committee. Jamie Morris here representing the Missouri Catholic Conference here in support once again of Senate Bill 160. Want to thank the senator for handling this bill once again. I don't know how many years we're up to now on this, changing sides of the building and everything, but no, I just want to reiterate what other folks have said. Obviously, to us, this is very common sense that for our Catholic groups on campus, obviously, if you want to go and evangelize, you want to bring everyone in. You'd be pretty poor, bringing folks in or being, exclusionary. But when it comes to leadership of these groups, obviously, you also want someone that knows and believes in the tenets of the faith, and that a group shouldn't be penalized for choosing leaders in such a way. And so, to us, this is a very common sense bill. And again, want to thank the senator and want to thank the committee for hearing this. And I'd be happy to answer any questions.
Questions? See none. Thank you. Anyone else to testify in support? Please come forward.
Thank you, Mr. Chairman and Senators. My name is Gary Hollis. I'm the State Director for Americans for Prosperity here in Missouri. I'm here today to testify in support of SB 160. As a national organization, we operate in 36 states around the country, and as a result, we get to see problems that arise not just here in Missouri, but across the country. As others have testified, this has been a problem throughout the nation, and 19 other states have moved to make efforts to change it through legislation as a result. We frequently have students come to us throughout the country because they have been denied funds, meeting space, or a club designation, all on the grounds of their political affiliation or sometimes religious affiliation. AFP has often opened our offices to many of these students. We've used our funds to provide them with resources that they should be able to receive from their college and university because they are paying into it through their student fees. These affected students are most often conservative or libertarian political groups or Christian or Jewish faith groups. Many times there's little ideological variance found among college faculty, and sometimes just the refusal of a faculty sponsor can deprive a student group of the resources that they're paying for and their ability to fulfill their college experience through joining a club. While this discrimination is most often found from far left faculty, I do applaud this bill for being all-encompassing. No student of any political ideology or faith should be discriminated against on Missouri's college campuses. As such, this bill should receive overwhelming bipartisan support. The freedom of speech and freedom of religion was written by our founders into the First Amendment for a reason. I encourage members of this body to reject any effort to suppress our students' freedom of speech or religion on campus. These freedoms are something that should be guaranteed in Missouri through all avenues of life and must be guaranteed to our students on college campuses. I will also point out that universities are not private entities. They are public universities that they receive taxpayer funds. One condition for receiving taxpayer funds should be a commitment to the principles found in our U.S. Constitution. These beliefs are held in such high regard for our organization that we included bills like this one in our legislative agenda that we've shared with many of you, and we plan to score on this issue accordingly when we release our scorecard post-session. In conclusion, AFP Missouri applauds this bill and respectfully requests this committee to advance it to the full body. As an organization, we will remain committed to the principles of free speech, freedom of religion, freedom of association, and freedom of press for all of Missouri's college students. Thank you for your time and consideration.
Thank you. Hold on. Anyone have any questions? I guess not. See none. Anyone else to testify in support? Anyone to testify in opposition, please come forward.
Good morning, Senators. Nimrod Chappell on behalf of the Missouri State Conference of the NAACP. I appreciate the opportunity to present testimony on behalf of not just the NAACP, but I have to tell you, the families that will be affected if this bill is allowed to move forward. I think it's interesting to just point out a few notes. First of all, as a lawyer who represents people who've been injured, cheated, and mistreated all the time, I don't hear complaints from families who are concerned that their kids have had some lack of ability to voice themselves in a religious context on college campuses. I hear all the time about the discriminatory treatment that is present on college campuses, in our elementary schools, in state government, and in public society just generally. So I find it very interesting that we're here today to talk about a bill for religious freedoms, to have a special carve-out in public institutions to ensure that no one's mistreated, even though there is not some crushing wave of litigation. And if you listen to any of these national folks who came into Missouri to reshape our policy, you can hear clearly that the law has already been defined, and they would like to prevent or forestall litigation. Let me suggest to you that that is probably not what's going to happen. That subsection B that allows for, talks about the expression of these ideologies is vast. If anything, I think that you're going to end up with a lot of litigation, that you're going to burden the public institutions. And that might be the part B of my testimony today, because where are there public institutions? If it's true that this bill has highlighted an issue that is so intense, where are our organizations? You know that they're in the building. They have lobbyists here. They have their presidents who come down all the time. And even though there's been a retreat from the idea that we should have equity and inclusion, and I'll talk about that in just a second, even though we're not going to get to Senate Bill 56 today, I think that we have to be realistic about who it is that we're trying to protect. If we're going to protect the children that are in these institutions, what is it? I think the Latin term is in loco parentis, right? They are wards of the university. The university has an obligation to protect them. Let the universities do their job. I think that not only will you advance litigation, but you're also going to truly reinforce segregation. Now, you ask, how is that going to happen? I think even now that most of the religious institutions that you've heard from today still have problems in their own ranks with inclusion. Missouri historically has had a horrible problem with inclusion, not just from the Dred Scott case where we couldn't figure out that a human being is actually a human being, but you could look at skin color and determine who was and who wasn't entitled to participate in democracy. Here we are asked to pay our taxes, and I understand the argument that this is not a tax issue in terms of how these student government funds are going to be used, but it is a pay issue. We are paying to attend a public university that's supposed to be open and inclusive, allowed for everybody to participate. And the truth is that the religious organizations that we're talking about under this bill have no intention of doing that. And how do we know that, right? They're not saying it. It'll be very interesting when we get to Senate Bill 56, when we get to the next bill that talks about whether or not we're going to talk about 1619 in educational settings, where the national organizations, where the religious organizations are to ensure that discrimination is eliminated there as well. If we're going to do for one, we got to do for the other. It is the golden rule. Don't let Missouri be another beacon or just fall in line with this cancer of racism that is already in our culture. We should be doing everything to ensure that people are treated just like people, not carving out exceptions such as this one.
Thank you for your testimony. Any questions? Well, I mean, I know I've heard of many universities, actually enacting segregation for, ensuring that people of color have the capability to escape other races. So is that segregation not occurring already, but willfully occurring in a university setting?
Senator, you're going to have to put some context to that, because when I take your question underneath my lived and educated experiences, I can tell you that Missouri has a long history of segregation. You think about Milton Turner, who had to educate black kids on the Mississippi River because it was illegal to actually
Well, I'm not
do that
talking
here.
about 50 years ago, 30 years ago. I'm talking about currently. It's happening in universities where segregation is occurring.
Are you saying that the universities are segregating students?
Yeah, absolutely. For people of color to have a place to go with their own, with their own race that they want.
Two things, Senator. First of all, there's only one race. It's just the human race.
Well, it's a human race. I
Right.
totally
So
agree. But it's
the idea that
occurring.
people are going to be divided by color, by a public institution. I'm from Missouri. Show me.
Okay.
It doesn't happen.
So will you put out a public statement if it's occurring that you come out against such policies?
I'm telling you, show me. Right?
Okay, what I will show you. I don't have the documentation, but I will show you. Will you put out a statement from your organization that it is in fact wrong and should not be engaged upon?
I don't even know what you're talking about.
What, I asked you this
just
question.
Tell me, Senator.
That
tell me what it is that
segregation
you're
is
saying.
occurring.
Where?
Is it wrong or is it?
Where?
It's happening on numerous universities
Name
all
one.
across this nation. I will. I'll bring it.
No,
to
I
your,
mean right now, Senator. If you're asking me,
It was
if I'll
occurring
actually-
at-
you're
in-
asking me if I'll issue a public statement about discrimination, harassment.
You said
in
if
the
I can
state.
show you, I will show you. Will you put out a public statement?
You can't even tell me what you're talking about.
Okay.
So show me, and then we'll talk about it. I'm happy and I'm available. You have, I'm sure, my contact information, and I'm available all the time for you.
Okay. All right. I'll be happy to provide that information, and I hope that you will then follow up with saying that it's incorrect policy to have those policies.
Segregation is illegal. Period.
Well, that's what's happening in numerous, and I know I've seen the reports of it. Okay. That's
But
fine.
you
I'll be
can't
happy to.
name one here, right? And this is the problem with this bill and this line of bills, is that people are going forward with these talking points, these ideas that are unverified, unsubstantiated, and when we try to get down to the point, we can't even find the facts. So here you are asking me for a statement about segregation and its viability in the state of Missouri right now from a public institution. I ask you for the facts. You're a senator on one of the most powerful committees in the state, and you don't have them. You can't even name
Oh,
them.
I will have them. I
No,
didn't
no,
bring the
you-
facts with them.
You
It
can't
is.
name them. That's the thing. We're here talking about this bill right now, right? We're talking about a whole line of bills that are going to eliminate the ability of people to participate in a fair way in institutions that they pay for with their tax dollars. And you asking me this question.
Yeah.
Not only is it unfair, sir, I believe
Hold on.
it's
I
disingenuous.
asked you, is it wrong to have these sorts of policies? Is it or isn't it?
I already told you that the law in Missouri
is
says
it?
that there is
Yes or
no
no?
segregation that shall be allowed
Okay.
in public
So
institutions.
if it's occurring, of which I said it should be wrong, and I would hope that you would put out a statement thereof.
I don't even know what. Show me.
Okay,
Show me.
I will.
And
I
let's
said I'll
do
show
a
you.
joint statement because I tell you what,
Okay.
when I find other instances about discrimination in the state, it would be nice to have a senator who's willing to stand up for the people in his state to ensure that the black, the brown, the female, the aged, the disabled, the perception of any of those in the above, including the religious, have an ally instead
Okay.
of somebody who's trying to take away their rights.
So you think this bill is taking away someone's rights?
I think it's given a special carve out to a group of people who don't need it. There's not an issue about religious discrimination that's fairly presented itself in any relevant context. What you hear about people is, as one of your supporters suggested, is that we should not engage in any more litigation. I'm telling you, this is going to increase the amount of litigation. They say that it's well-settled law. So what are we doing if it's already enshrined within the Constitution and the policies of these universities? And I also point out that the universities aren't even here to support this measure. I think that's telling.
Well, I think it is telling that they don't support the First Amendment and people's capability to associate amongst their faith on campus.
Why don't you think they support that? You would think that there would be a ton of litigation. Show me the case.
There is a ton of litigation.
Where? No, there's not. They just testified that there's not. They said that there has been litigation in the past, but it fails in comparison to the number of cases that have been brought forward by people who have tried to attend universities, going all the way back to Lloyd Gaines, because they've been excluded on the basis of how God made them.
Okay.
How's that for a religious exception?
Well, where was the NAACP on Amendment 3?
What does that have to do with this?
I mean, you're wanting to broaden the scope of where we're at with, making sure people are considered people. Where was the NAACP on Amendment 3?
We believe that human beings must be in charge of their body as a people
Okay,
who've been
thank you. I appreciate
subjugated,
it. Any
as a
further-
people who've been subjugated
Thank
to slavery and every other vile thing that you can do to a human body. We believe that everybody has the ability.
Dehumanizing another human being. That's exactly right. as
No,
well.
well, that's what happened to us, and so we think that everyone needs to be in charge of their
So
own body.
having into the unborn is a better situation. Okay.
Senator, whenever you want to have a discussion on abortion, we can.
Okay. Well, I mean, you just said your state where you stand. Any further questions? Seeing none, thank you.
I'll look forward to that evidence that you're going to bring forward, Senator.
Oh, absolutely. I look forward to it.
Thanks.
Any further testimony against? Seeing none. Anyone for informational purposes? Seeing none. Any closing statements? Oh, I'm sorry. My apologies.
Thank you. Sage Quorum with the American Civil Liberties Union of Missouri in opposition to this bill. The bill is really, the question at issue is not whether students have freedom of belief or the ability to associate on campus, but really it's about the taxpayer dollars that all students are paying equally into and the discriminatory use of those funds. So that's our opposition to this bill. Thank you.
So you're in opposition?
Correct.
Oh, okay. All right. All right. Thank you. Any questions? See none. Anyone for informational purposes? Well, I said opposition. No one raised their hand or stood up. That is absolutely what happened.
Good morning. Sharon Gowie Jones here on behalf of Promo Missouri in opposition to the bill. I wanted to clarify a couple of things about this bill that are different than the other 19 states that have passed some sort of religious organization anti-discrimination law. This bill, unlike those, does two very important things. One, subsection B, and all of these are in the disjunctive. If you look at where the meat of the bill is, subsection B prevents discrimination based on the expression of viewpoints by either the association or its members. That is not leadership. That is not having something in your bylaws like a tenet of faith. That is how that is taken and used on the campus. And to me, that means that we are now creating a conflict of laws between our anti-discrimination laws and things like the Missouri Human Rights Act and the Civil Rights Act federally, and what we are telling people on campus they can and cannot do. That is different than what we see in most other states. I believe Louisiana is the only other state that has that kind of language in it. Given the fact that all of those are in the disjunctive, the testimony that you've heard about this being about leadership is inaccurate as to the actual language of our proposed bill because of that subsection B. So please take a look at that. The other thing that is different than all of the case law that we've heard talked about and most of the testimony is that this goes beyond religious freedom. This is also about political and ideological organizations, which means that we are not simply protecting people's freedom of association under the First Amendment for religious purposes. We are protecting any kind of ideology. That is incredibly broad and goes far beyond both the case law and the laws that we see in other states, which are primarily focused on religious freedoms. So we oppose the bill in general, but I just wanted to point out that those two pieces in particular make this very different than what the courts have been talking about and what we see in other states. I'm happy to answer any questions.
Any questions? See none, thank you.
Thank you.
Anyone else to testify in opposition? Please come forward.
Good morning, Mr. Chairman and members of the committee. My name is David Lee Brush. I'm with the Missouri Equity Education Partnership, and we would like to go on record in opposition to the bill. We have nothing more of substance to add because the people who've already said basically everything we're going to say. We do believe that organizations on campus should be able to democratically elect their leadership and reflective of their ideology. And nobody is any one thing. You can be more than one. You can be LGBTQ and a Christian. You can be more than one thing and be in a club and still want to have that kind of leadership. So, like I said, everybody's pretty much said everything we're going to say. We just want to be on record. Thank you so much.
Thank you. Anyone? Questions? Thank you.
Thank you.
Anyone else in opposition?
Hi, my name is Malcolm Gerhardt, and I'm speaking in opposition. I want to briefly talk about I'm a member of a student organization on a public campus, a public university, and speaking from personal experience, this is a non-issue, right? When we talk about leadership, the people of the groups are electing their leadership. The people are going to elect people that align with the leadership, with what they want their leadership to be, and more times than not, those people's beliefs or those people's identities are going to align with those groups' beliefs and identities. And if it doesn't, that more so speaks to the people, the democratically elected people and the people in that group more so than the group's ideals. People and groups change over times, and I think we should allow that to happen. And also I want to briefly talk about your point about the segregated groups on campus. There aren't any. If any, there are student groups that are dedicated to marginalized groups. They don't ban people who are not part of that group. They allow all people to come in, but they are specifically focused for marginalized groups to have a place to be on a predominantly white campus, a predominantly cis or straight campus, and it just allows them to have a space. Of course, they're not banning people from their space. They're just having a space for themselves. So I just want to say that I am in opposition for this bill. Are there any questions?
Anyone have any questions? See none. Thank you for your testimony. Anyone else to testify in opposition? See none. Anyone to testify for informational purposes? See none. Senator?
Mr. Chair, I want to thank you for your time. I would encourage the committee to look at the 19 other states that have passed legislation that's very similar to this, if not exactly the same, and the bipartisan nature that it has been passed by in some other states. And again, thank you very much for the time today. I appreciate it.
All right, that concludes the hearing on 160.